Roman law began with the 12 Tables in 451. 450 BC, a set of laws inscribed on bronze tablets and publicly displayed in the Roman Forum. This was Rome's first attempt to create a public and standardized legal code, addressing everything from family rights to criminal acts. The 12 Tables are considered the foundation of Roman law, influencing all subsequent legal developments. As Rome expanded, so did its legal system, evolving to meet the complexities of an ever-growing empire. The introduction of the praetors, judicial magistrates, was pivotal as they could create new laws, edicts, to address cases not covered by existing statutes, showcasing the system's adaptability. Roman jurists played a crucial role in shaping the law, interpreting existing statutes and offering advisory opinions on complex legal issues. Their writings, though not legally binding, greatly influenced judicial decisions and the development of legal principles, marking the early stages of legal scholarship. The Romans were among the first to introduce the concept of natural law, a set of universal principles inherent to human nature and reason. This idea, championed by figures like Cicero, suggested that certain legal rights and principles existed independently of written laws, influencing Western legal thought for centuries. Perhaps the most significant development in Roman law was the compilation of the Justinian Code in the 6th century AD under Emperor Justinian I. This monumental work collected and organized centuries of legal texts, edicts, and scholarly writings into a coherent legal system, laying the groundwork for many modern legal codes. Roman law was divided into two main categories: the law applicable to Roman citizens and the law applied to foreigners and transactions between citizens and non-citizens. This distinction highlighted Rome's legal adaptability and its capacity to govern a diverse empire. The Roman legal process was remarkably advanced, featuring formalized procedures for filing lawsuits, presenting evidence, and advocating before judges. The development of the formula system, where specific legal charges and remedies were outlined, demonstrated Rome's methodical approach to justice. Roman law covered both public aspects, such as administrative and criminal law, and private aspects, including property, contracts, and family law. This comprehensive legal framework addressed the full spectrum of societal and interpersonal issues, ensuring order and justice within the empire. The influence of Roman law extends far beyond the ancient world, serving as the foundation for the civil law tradition, which is prevalent in much of Europe, Latin America, and parts of Asia and Africa. Concepts like contractual obligations, property rights, and legal wills have their roots in Roman legal principles. Before the Justinian Code, the Statutes of Gaius, written in the 2nd century AD, was a pivotal legal text that introduced key concepts like persons, things, and actions in law. This treatise provided a systematic overview of Roman law, influencing both the structure and content of the later Justinian Code. Roman law evolved to grant women certain legal rights and protections, such as property ownership and financial independence under certain conditions. This progression, however, was limited and reflected the patriarchal nature of Roman society. Roman law institutionalized slavery, defining slaves as property rather than persons. However, it also provided mechanisms for manumission, the act of freeing a slave, which could be initiated by the slave owner or in some cases earned by the slave. The Romans were pioneers in developing the concept of contracts, including stipulations, legally binding verbal agreements, and written contracts for transactions and services. This innovation laid the groundwork for modern contract law. Roman law addressed torts or civil wrongs through the lex aquilia, which detailed remedies for personal injury and property damage. This legislation is considered one of the earliest examples of tort law, emphasizing compensation for wrongful acts. The Romans had laws dealing with debt and insolvency, which could lead to severe penalties for debtors, including servitude. Over time, laws became more lenient, reflecting changes in societal attitudes toward debt and economic hardship. During the Renaissance, there was a renewed interest in Roman law, leading to its study and reinterpretation. This Roman law renaissance influenced the development of legal systems in many European nations. The Roman military had its own legal system, dealing with offenses ranging from desertion to insubordination. The strict discipline and legal structure within the army were key to maintaining order and efficiency. Although not environmental law in the modern sense, Roman laws included regulations on public lands, water use, and mining, showing an early awareness of resource management and environmental concerns. Roman citizens had the right to appeal judicial decisions, a practice that emphasized the importance of justice and fairness in the legal system. This concept of appellate review is a cornerstone of many modern judicial systems. Roman legal principles like justice for all, the importance of written laws, and the right to a fair trial continue to influence contemporary legal thought and practice. The Roman legal system's emphasis on order, equity, and rationality has left a lasting legacy on the rule of law worldwide. Our journey through time comes to an end for today. We embark on new adventures every week. If you relish the experience, please like and subscribe.